In today's video, I'm going to take a look at non-disclosure agreements and look at the essentials. Now, a non-disclosure agreement can also be called a confidentiality agreement. So let's take a look. Firstly, you need to understand that in relation to intellectual property, there are quite significant rights and protections. So patents and trademarks, for example, can be registered, and copyright protection exists in other works, for example, in film, images, written words. And there is the Copyright Act and various common law protections as well. But in relation to ideas, you cannot copyright an idea. That creates a problem for anybody going to enter into discussions or talks with somebody else if they have maybe a new product or a new idea or whatever, and they need some sort of confidentiality, and they need to be able to know that they can discuss the thing openly with the other party without getting shafted. So a non-disclosure or confidentiality agreement may be useful in a situation where you're looking at a new business venture, perhaps a new product, a potential investment, or indeed just a good idea. Remember, you can't copyright an idea, but you may be able to give some degree of protection and solace to yourself with a non-disclosure agreement. So a non-disclosure agreement may be the answer to provide some protection. The non-disclosure agreement should contain a disclosing party and a recipient party. So if you're going to enter into discussions, you may be the disclosing party. The type of information that will be disclosed will need to be set out in the agreement. For example, it could be technical or financial information. It could be a new idea or strategy or tactics. You'll be looking to protect these in the agreement. Confidentiality of the information then is what you're looking for, and you're looking for protection in relation to what's disclosed. You need to provide also for the return of any documents or software or any other data that might be disclosed as part of your discussions or negotiations. What happens if there's a default? Well, your non-disclosure agreement should provide for this, but basically you're looking for two types of relief. One is an injunction and the other is damages. So you'll be looking for injunctive relief and or damages. Important clauses to include in a non-disclosure agreement would be that there's no representation being made by you, the disclosing party, as to the accuracy and completeness of the information disclosed. This is a sort of a boilerplate clause. Another one would be that the agreement is being drawn up at the request of the disclosing party, so it would be enforceable by the disclosing party, that's you, and any variation or waiver would be at the behest of the disclosing party, again, that's you. You'd also want to set out the duration of the agreement, how long it's supposed to last. You'd want to also make a provision that the non-disclosure agreement cannot be assigned to another party, and you need to provide for the applicable law. Is it going to be Irish law, UK law, American law, or whatever? And obviously there's going to be a signing place for both parties. So a sound agreement, a non-disclosure agreement, it can protect your good ideas or novel products, and it can help progress talks for new business arrangements, partnerships, or joint ventures. My contact details on the screen. If you find this video useful, you might give it a thumbs up down below and be interested in subscribing to my YouTube channel.